You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 110, Shifting the Case Back to the USPTO. My name is Adam Diamond, a registered patent attorney and founder and owner of Diamond Patent Law in Los Angeles, California. I can be contacted through my website at diamondpatentlaw.com, that's DIAMENT patentlaw.com, or call me at 424-281-0162. Before I go into this episode, I wanted to just briefly talk about two more patent acronyms that you might come across. I did a whole episode on patent acronyms, and I actually forgot two of the most common ones, and these are the ADS and the IDS. ADS stands for Application Data Sheet. I had a whole episode on how to fill out a patent application data sheet. It's just a form where the patent office wants to know more about you and your contact information and basic stuff like that. The other one is the IDS, and I also had a whole episode on this one too. It stands for Information Disclosure Statement. This is a list of patents, patent applications, and other documents that you are required to disclose to the patent office if you think that these things are relevant to your invention and might impact patentability. So if you're improving on a known device, you'll have to include that known device to the patent office. And all that goes into the IDS, the Information Disclosure Statement. Okay, so in this episode, we're going to go back to litigation. Let's just briefly review what I've gone over so far. Episode 103, I talked about an overview of patent litigation. In episodes 104 and 105, I talked about cease and desist letters. In episodes 106, I talked about what goes into a patent infringement complaint. And in episode 109, I talked about how to respond to a patent infringement complaint. You can see that there are some episode numbers in there that were skipped because I went back to some other topics besides litigation. This episode is going to be a little bit of an overview from what I talked about a long while back called post-grant proceedings, and these were in episodes 77 through 82. So go back to those and listen to those if you want more details about what I'm talking about here. So why am I talking about them again? Remember, there are really two different kinds of courts that hear patent issues. One system is through the Patent Office itself, and this is called PTAB, the Patent Trial and Appeal Board. These aren't courts, or this isn't a court that you typically think of as a court. And there have been a lot of complaints about them because they're deciding whether patents are invalid or not. But it's not what's called an Article 3 court. An Article 3 court is what you think of as federal courts, and it's an Article 3 of the Constitution. It's an Article 3 of the Constitution where it says there'll be a judicial branch of the government. And some people have wondered whether even having this separate court system called the Patent Trial and Appeal Board was even constitutional. But in 2018, the Supreme Court said that it was. Now, why is it important that there are two different court systems to determine patent validity? At the USPTO, the Patent Office, they can't decide infringement. All they can do is decide whether a patent was validly granted or not, so they can invalidate patents. An Article 3 court, like a federal district court, that's where you have two parties against each other, where one party is saying that someone is infringing their patent and they want damages. So you could see that maybe there might be a problem that would occur. What would happen if someone sues someone for patent infringement in a federal district court, and the judge or jury says that the patent is valid, but the defendants then go to the patent office and ask a patent judge to say that the patent is invalid? This could cause a mess because there might be two different rulings on whether the patent is valid or not. And if a patent is not valid, then you can't sue for patent infringement. And this is where this episode comes in. Let's say that you just got sued for patent infringement, and you don't think that the patent is actually valid. But things can get really expensive if you take this through a trial court, which is the regular district court. You have, expert witnesses, and you have, the jury panel and all that kind of stuff. What you can do is you can ask the patent office to take a look at this patent again in what's called a post-grant hearing. And when you do that, the trial court is supposed to stop what they're doing and wait for the patent office to decide on the validity of the patent. If the patent is found invalid, then there's no reason to continue the trial because there's no more patent. But if the patent is found valid by the Patent Trial and Appeal Board, then the trial court can continue to determine infringement. I went through 5 main ways that a patent can be invalidated using the Patent Office. The most common one having to do with litigation is called an inter partes review, and I talked about that in episode 77. There's also a covered business method review, and that's in episode 78. These are going to be the most common ones that are used to stop the trial court. Now, once the defendant has filed an inter partes review or covered business method, they'll ask the district court to stay the patent trial suit. To stay a trial means to temporarily halt the trial. The Patent Office is supposed to make a determination within 18 months of the request, and based on the outcome of the inter-parties review or covered business method, then based on what happens there, the trial may either continue or it may effectively be over. So this is one step in the patent litigation process that you should be aware of, because it can take the case out of the trial court temporarily and put it back to the Patent Office and then possibly shift back to the trial court. And if you want help with your patent application, trademarks, copyrights, responding to rejections, appeals, or anything else related to your invention, you can contact me directly through my website at diamondpatentlaw.com. That's DIAMENT, patentlaw.com. Email me at adam@diamondpatentlaw.com or call me at 424-281-0162. I'm Adam Diamond, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamond. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamond at patentingforinventors.com. That's patentingforinventors.com. Or call Diamond Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.